All right, today we're diving into a really fascinating and honestly pretty intense area of law called nervous shock. We're going to unpack what happens when those invisible wounds, the trauma you can't see, become the basis for a very real legal claim.
So let's just start with this scenario. Picture this. You witness a truly horrific car accident. You're not physically hurt, not a scratch on you, but the image is just burned into your mind. So the big question is, can you actually sue for that? For the psychological trauma alone? Well, that's exactly what we're going to get into.
Okay, so let's get right into it. First up, what does the law actually mean when it says nervous shock? Because, it's not just about feeling upset or being frightened. Oh no, it's way more specific than that.
At its core, nervous shock is a type of tort. That's a civil wrong, where someone's carelessness causes an event so traumatic that you end up with a genuine, recognized psychiatric illness. We're talking about things like PTSD or clinical depression, the real deal. And this is probably the most crucial point to get right off the bat. The law draws a very hard line in the sand here. Simply feeling grief or sorrow or distress, as completely real and awful as that is not enough for a legal claim. We're talking about a medically diagnosed illness.
But to really get why the rules are what they are today, we got to go back in time. Because the law's starting point on all this was, well, let's just say it was incredibly rigid and frankly, not very sympathetic.
For a long time, the courts basically said, look, if you weren't physically hit, you don't have a case. That's it. The whole idea of a purely mental injury was seen as too remote, too hard to prove. It was a complete legal brick wall for victims of trauma.
So how did that brick wall come crashing down? Well, it wasn't one single event. It was actually a series of powerful, often tragic human stories that forced the law to evolve. Let's walk through 3 of the cases that absolutely changed everything. Our first case takes us all the way back to 1901. Imagine this. A pregnant woman is working behind the bar in a pub when suddenly a horse-drawn van comes crashing right through the wall. It doesn't actually hit her, but the sheer terror of it all causes a shock so severe that it leads to devastating consequences.
So the court had this massive question on its hands. Was that old rule absolute? Could fear alone, this profound nervous shock, without a single physical touch from the van, actually be grounds for a lawsuit?
And here it is, the first major crack in that wall. The court decided yes, she could recover. They recognized that a shock that leads to a real illness is an injury in itself. That old, antiquated rule was officially on its way out.
Okay, let's jump forward to 1925. This next case adds a whole new layer of complexity. Here, a mother sees a runaway truck rolling down a street, but she's not afraid for her own safety. She's terrified because her children had just walked down that very same street. The terror she felt for them was so extreme, it proved fatal.
So you see how this pushed the boundary even further, right? The first case was about fear for yourself. Now the court had to ask, does the law also protect you from the shock of fearing for your immediate family?
And again, the law expanded. The court said yes, a claim can be made for fear for your loved ones. But, and this is a really important but, it had to be based on what you saw or heard with your own senses. The circle of protection was getting wider. Our final landmark case brings us all the way up to 1982, and it's just heartbreaking. A mother isn't at the scene of her family's car accident. She's 2 miles away. She rushes to the hospital, only to be confronted with the horrific results, what the law now calls the immediate aftermath. This was the next great legal puzzle. How far can you stretch time and space? Do you have to witness the crash itself, or is seeing the horrifying consequences just moments later enough to ground a legal claim?
So let's just quickly recap this whole journey. The law went from a hard no without physical impact to allowing claims for fear for yourself. Then it expanded to fear for your family, and finally, it grew to include those who experience the immediate, horrifying aftermath. What an evolution!
So after that whole century of change, where does the law stand today? Well, it's gotten more complex, and it all really boils down to one crucial distinction. Are you considered a primary victim or a secondary victim? A primary victim is someone who is directly involved and actually in the zone of physical danger. Their path to making a claim is a little more straightforward. A secondary victim, on the other hand, is a witness, someone outside that immediate danger zone. And for them, the law has put up some very specific hurdles.
These hurdles are called control mechanisms, and they came right out of that heartbreaking hospital case.
To have a successful claim, a secondary victim has to prove three things. First, a close tie of love and affection with the victim. Second, proximity. You had to be close in time and space to the event or its immediate aftermath. And third, you had to perceive it with your own unaided senses, not, say, by watching it on the news later.
Okay, we have covered a lot of ground, from 19th century courtrooms to modern legal tests. So let's boil it all down to the absolute essentials you need to remember.
So, to sum it all up, a nervous shock claim demands a recognized psychiatric illness, not just grief. The law evolved dramatically to get to where it is today. And now, the path to a claim really depends on whether you are a primary victim who is in the zone of danger or a secondary victim who has to pass those three key tests: relationship, proximity, and perception.
And that leaves us with one final thought to chew on. This whole area of law was shaped by the science and understanding of trauma from decades ago. But our knowledge of mental health is constantly evolving. So the real question is, as science gives us an even clearer picture of psychological injury, where is the law going to draw its next line? Something to think about. Thanks for joining me for this explainer.